for what you've all have done, paying attention. We notice those things sometimes, and we really appreciate it. You know, there are so many things about this case that makes it unique. We have a former officer charged with murder. Very unique. We're using a technology in this case that is pretty new. It may be commonplace in the future, but this is new stuff for a lot of people involved. And you know, the emotions are high in this case, and it seems like everyone around has an opinion about it, but you all have heard the facts, and you are the trier of fact. And as you sort through this, the good news is that you will have a clear pathway to getting to where you need to be. And it is a tried and true method that has been used for hundreds of years. First of all, you have to listen to what Judge Shanahan says the law is. You sat through all the facts. You can choose to believe or disbelieve anything you want concerning the facts. It's your job to search for the truth. It is your job to search for the truth, and that's what I hope you do. As you have heard before, and voir dire, and Judge Shanahan will tell you again, you may not permit sympathy or prejudice to enter into your decision. You may not even consider punishment. For instance, it would violate your oath if you said something like, "Oh, he looks so young," or "I wonder if he's going to go to jail." That's not your job. I don't like people who have marijuana in their car. Cops deserve a break. Sympathy has no place in this courtroom or in your deliberations. Factors outside of your instructions must be ignored, no matter how hard that may be. You swore to that, and we counted on that when we selected each and every one of you as jurors. When we were thinking about our closing arguments, Mark and Rick and I decided that Mark would lay out the elements of the case of every crime we had to prove, which he did this morning. And I think you could see what a good prosecutor Mark is and Rick is, why the county's blessed to have them. What I want to do now is to lay out some observations about what the evidence that I think is important when you go back there and analyze and think about all the evidence you've heard. The first thing is this: you are going to have all the exhibits, clothes, photos, diagrams, videos, and the rest back in the jury room. The judge, and I'll touch on this briefly, has permitted expert testimony in this case also. And you will have Grant Frederick's report back there that you can view. I think Grant Frederick was an impressive expert who analyzed the video and the video evidence in this case. And although the defense had every right to call a video expert, they didn't. We called a police use of force expert in our case. Again, very professional, very impressive. They called an expert on the police use of force, which we refer to as the volunteer expert. He has never testified ever in his life against a police officer. He was upset with the indictment, thought he was innocent by watching something on TV in Columbus, Ohio. He wrote his report 10 months before the video expert had prepared their report so he could see what it was about. The judge is going to tell you that you can believe all, some, or none of his testimony. And I would suggest to you that it is worthless. In the face of a very clear video, and you're going to have this all back there. Thank God for the body camera. He claims Mr. Tenzing was dragged. It never happened. He said he had to stop the threat. There never was one. Even Mr. Tenzing, in the overwhelming face of obviousness of the video where it's clear he isn't dragged, now has changed his story. Yesterday, for the first time, we heard it was his perception he was dragged. Look at the statement that Cincinnati Police Homicide took 2 days after this incident. What happened? He was very positive of that. He was very positive of that. But when you see the video compared to that statement and hear from our expert who does this for a living, that story just doesn't cut it. So now we're down to perception, not reality. So you moved to your plan B, now we're dealing with perception. I was dragged. I was perceived as being dragged. Give me a break. The defense has become almost so comical with their word games. When you intentionally aim a .40 caliber gun at someone's head, pull the trigger, you're not killing them purposely. You are now stopping a threat. Let's just cut to the chase here. You are going to hear exactly when the gunshot happens. You are clearly able to see exactly where Tenzing was and was doing when he pulled the trigger. Go back there and watch it 100 times. Peggy, put that frame up. Go to the next one, Peg. Go back to the other one. This is not fun. Car's not in motion. Gun's up here. Does this look like that fantastical story he told yesterday, where he's laying on the back and doing some he is being dragged, he has to reach up around and shoot Sam? You know, as the finders of facts, I like to use this analogy in front of juries. You are like surgeons doing your job over a patient. And the defense is trying to throw red pepper in your eyes so you can't see the truth and do your work. What in this case is the red pepper they're throwing in your eyes? The volunteer expert, self-admitted he's not a video expert, who never testifies for anybody but a policeman, rendering some nonsensical opinion totally contrary to the video. He wrote the opinion 10 months before our expert laid out the video for him. How about the defendant's story? After being absolutely firm of the falsehood that he has perpetrated for months, Now he sees what the jury sees and realizes that this junk story can't stand up in the face of overwhelming evidence. Now he claims now it's just his perception he was dragged. You know, one of the greatest tools you can use in judging the truthfulness of somebody is the consistency of the story and the number of times they've told the same story. You think these witnesses were coached? My perception, stop the threat. And this is new for me, but I heard it from multiple witnesses. Mash the accelerator. I've never seen him so white and pale. Here's some of the other pieces of red pepper that's been thrown at you, and I'll touch on them briefly. We tried to interject race. We did. The state of Ohio did. I wasn't wearing that shirt. I didn't collect that shirt from him that day. The criminalist did. It does have probative value. Take a look at it and see if it's damaged in any way from being dragged 20 feet. They're the ones that introduced his character. We can't introduce his character until they did it. And we're sitting here with a report from the University of Cincinnati where his racial disparity of pullovers is larger than anyone else on the force, and he has more citations than anyone else on the force. They place his character at issue. They show prior stops he made. Both, remarkably, African-American drivers with no front license plate. And you know, just as an aside, the guy's with his wife and his 4 kids. Does he really have to handcuff the guy in front of his 4 kids? They placed his character at issue. Not only did we not, we couldn't. Mr. Matthews talks about reasonable doubt. Judge Shanahan's going to explain to you exactly what it is. It's not that complicated. To sum it up, and she'll tell you, you just have to be certain, because everything is up to possible doubt. You just have to be sure. That's all you have to be. Some more of the red pepper in your eyes. It depends on what drag is. It reminds me of that question, it depends on what is. I think everybody knows what being dragged means. But he was either perceived to be dragged or dragged. That's all we know. You know, one of the last vestiges of a desperate defense is when an expert gets on the stand and you say, how much have you been paid? I got news for you. I know you guys aren't getting paid much. Everyone here's getting paid. I'm getting paid. Mr. Matthews is being paid. The judge is being paid. I don't understand the purpose of that. I don't understand it, except to confuse you, as if something's wrong with an expert because he got paid. Another piece of pepper. He had to have turned the tires. You know, don't leave your common sense at the courthouse steps. You can apply your common sense to situations like this. We're dealing with a car that had over 200,000 miles on it. All right? Do we know what the alignment was on that car? My brothers and I, all through college, drove a car that if we didn't turn the wheel physically to the right, it would have gone left, hard. We just didn't have the money to fix it. And when Grant Frederick said that the car rolled slightly, maybe 1 or 2 feet before the shot, don't leave your common sense. When you start your car and you put it in gear, does it sit still? Without even touching the accelerator. Without even touching it. Don't use 20/20 hindsight. That's called a trial. That's what we do in every trial. We look back on behaviors and make a decision. Present our case to the jury, argue the case, let the judge describe the law. That's what we do in trials. Then we heard that Ray Tenzing feels terrible. Didn't come from him. He was on the stand yesterday a long time. I never heard him say one thing about that. But you are the sole finders of fact, as I said, and nothing we say is evidence. Nothing Mr. Matthews said was evidence. Rick, Mark, and I have been doing this a long time, and this case will be, for me, always something, for many reasons, on many different levels, I'm not going to forget about. But evidence-wise, there are 3 things I will take away from this case. 2 are testimonial, and 1 is an exhibit. First of all, the testimony of the defendant. It's not the fact that now we're dealing with perceptions instead of reality. It's not that. It was the tears. You're going to have a video of his questioning, pictures of him at the hospital, videos of his questioning 2 days later by the homicide. You tell me if he's upset. The place to be upset, I think, if you use your common sense, would probably be at the crime scene after you just blew someone's brains out. But that's not what happened. He wasn't crying yesterday for Sam or his mom, his fiance, his brothers, his sisters, or his kids. He was crying only for himself. They were not tears for the life he took, but it was for the life he was trying to save. The second thing that's going to be hard to forget about was also testimonial, and that was Alicia Napier. She's totally uncompromised by any bias or prejudice, unlike his expert. And I want to add something real quick, because there's been some discussions about the responding UC police officers. People have asked me if I thought or we believe that they were lying. And I'll tell you that in the heat of the moment, I think some people get confused, but you're going to have the film. Go in the back, play it at real time, listen to when the gunshot goes off, and when the car accelerates at a high rate of speed. It's very clear. Anyway, going back to Alicia, she saw the stop. She saw Tenzing standing next to the car. Remember that he was standing very close to the car. She saw Tenzing struggling to pull his gun, however short a time. Then she heard a gunshot. She saw Tenzing falling away from Sam's car. She actually thought, as Mark said, that Tenzing was shot. She never saw any dragging. She was an incredibly frank, unbiased, fair witness who didn't have to come forward. When I asked Tenzing about it yesterday in my cross-examination, his only answer was, to explain her observation was, well, she saw it through her rear view mirror, her side view mirror. So what? There's an excuse for everything. The third thing I'm going to remember is not testimonial, but it is an exhibit, the body cam, and how the expert was able to break it down. The video is the ultimate witness. It doesn't alter reality or change its story. It has no bias or prejudice. It consistently tells what it saw, whether it's the first time or the 1,000th time. And you will have this ultimate witness with you in the jury room. I'm sure in the future this technology is going to be commonplace, and maybe my kids will, when they try cases, will be using it. But just like I said in the opening, this video exposes Tenzing's lies. After 2 days later, it's too bad Sam didn't have that luxury of 2 days, isn't it? He wanted answers right now, right now, right now. He kills somebody, he gets 2 days. Go talk to a lawyer. 2 days later, even after seeing the body cam, he says he reached through the steering wheel to turn off the car. Proven false. His left arm got tangled in the steering wheel. Proven false. The car sped off with him stuck. Proven false. He was being dragged along the pavement by his left arm. Watch the timing of the video and the timing of the shot in this video. Remember Alicia's testimony and look at his uniform. It's pristine. That was proven false. How his body was almost parallel to the ground. It's false. How then, hanging on for dear life, he pulled his pistol. Does this contortionist move? Why did he have to come up with that ludicrous story? That he has long arms and he had to reach all the way up and then bend back down? Mark demonstrated it perfectly. I'm glad I'm not going to get on the ground like Mark did, but it's simple. He has to explain the path of the bullet. Bullet comes up here, goes down here. So what's the likely result of shooting another in the head with a .40 caliber semi-automatic gun? More word games. Stop the threat. How about they're going to die? because that's what's going to happen. Look, the evidence is overwhelming that Raymond Tenzing purposely killed Sam DuBose. And the evidence is overwhelming that there was absolutely no justification for it. One last thing. The defense is urging that you determine that there's justification. Our job in proof, to prove beyond a reasonable doubt, is the murder and/or the manslaughter. If he alleges, and the judge will instruct you, if he alleges that it was justified, the burden shifts to him. If we prove that he purposely killed Sam, the burden, and he says it was self-defense, the burden shifts to him. And by a preponderance of the evidence, he has to prove to you that's what happened. You know, everyone in this courtroom has a job to do. We do, Mr. Matthews does, the judge does. The only way the state does not get the justice that is cried out for is if any of you refuse to adhere to your oath and that you swore to follow the law. Apply the facts, follow the law as the judge instructs, and if you do, you will find Ray Tenzing guilty of murder. Thank you.